Mr. Chairman, committee members, thank you so much for having me. Please note from the outset that folks, my remarks will really be more on the Roe.
Can you
certainly,
lean in
certainly
a little
the Roe,
bit? Thank you, sir.
viability standard. Can you hear that?
Yes.
And not really as much on the Ninth Amendment, although I agree wholeheartedly with Professor McLeod's comments. In answer to your question, yeah, my name is Nate Kellum, and I'm President and Chief Counsel with the Center for Religious Expression, which is a nonprofit 501c3 legal organization. And what we do is we defend religious liberties in federal courts all over the country. I've been asked to testify today regarding the constitutional implications of Senate Bill 1236, the Tennessee Heartbeat Bill. And I can and do testify that this bill is constitutionally defensible and, in my opinion, would survive Supreme Court scrutiny. In 1973, in Roe v. Wade, the Supreme Court interpreted the U.S. Constitution to bestow on women a right of access to abortion. But at the same time, the court acknowledged the state's profound interest in the life of an unborn child. And the Roe court really struggled with the balance. How do you balance these two competing interests? Particularly the point of the pregnancy. At what point in the pregnancy does the state's interest kick in? At the time that Roe was decided, the existence of life in the womb was debatable, depending on religious, philosophical viewpoints. The Supreme Court was really wary of trying to decide the question of when does life begin, whether at conception, birth, or sometime in between. So instead of directly addressing the question in Roe, the court punted, opting to use fetal viability outside the womb as a marker for determining the state's interest and when it would begin. But of course, a lot has changed since 1973. We know a lot more about the existence of human life in the womb than we did back then, especially with the advent of ultrasound technology. The life inside the womb now is indisputable. Also, we know a lot more about the viability of life outside the womb. That's changed considerably over the years. When Roe was decided, most medical authorities did not consider babies viable until the third trimester. Following this line of reasoning, the Supreme Court introduced this trimester framework that we're so familiar, prohibiting states from prohibiting or regulating abortion within the first and second trimesters, thinking viability did not initiate until the third. But the trimester standard was obsolete almost as soon as it was uttered. By 1992, the plurality of the Supreme Court in Casey versus Planned Parenthood rejected the trimester framework, and importantly, they did so without giving a substitute for how you assess viability, supplying no other way to gauge this vague standard. And this has created significant enforcement problems for states like Tennessee, because viability outside the womb is far from universal. Also, generally speaking, viability line is becoming closer and closer to conception as medical advancements progress. Even the very meaning of viability is subject to debate. The bill before this committee illustrates that quandary, showing how the medical definition of viability does not match on how the courts have routinely defined it. Given this tortured history and backdrop of abortion rights, it is my opinion that the proposed Tennessee Heartbeat Bill 1236, as amended, is constitutional and would be considered as such by the U.S. Supreme Court. And I say this for several reasons. One, the Roe viability standard is no longer settled law, and the Supreme Court will likely get rid of this impractical standard at its earliest opportunity. Two, even if the viability standard survives, the Supreme Court would recognize the Tennessee Heartbeat Bill meets this standard in light of current and medical understandings of viability. And three, in either event, the bill properly focuses on its valid interests, protecting unborn life, which is really all this body can possibly do. First, the Roe viability standard in its current form simply does not work, and it will eventually be revisited. There can be very little doubt about that. Viability outside the womb is no longer a good gauge, if it ever was, for assessing the timing of the state's interest in unborn life. It is not universal, varying among different individual pregnancies, depending on a number of factors, like race, gender of the child, health of the mother, medical services available. Also, the average viability continues to go down. closer to conception. When Roe was decided, viability was considered to be, by medical authorities, to be at 28 weeks. By the time Casey was decided, it had gone down to 24 weeks. Today, it's considered 22 weeks, perhaps a little less. Medical advancements make viability, as described in Roe, a moving target. This standard, already unworkable, will prove to be even less so in the days ahead. The time has come for the Supreme Court to jettison this standard or tie it to a more reliable, consistent measure of viability, as this bill does, in referencing the medical understanding of the viability term. We have received signals from the Supreme Court that the viability issue is ripe for revisiting. In the 2007 Gonzalez versus Hart case, where the court upheld the ban on partial birth abortion, blurred the line between pre-viability abortions and post-viability abortions, did not even consider viability in its analysis, implicitly recognizing that it is not a functional bright line for the court to follow. When convinced of error, the Supreme Court has always been willing to depart from precedent, done so recently in this last term a couple of times, in reversing precedent that had been in place for decades. And a departure here, though mired in certainly a divisive issue, is a natural one. The Supreme Court has never offered a constitutional justification for this viability standard in Roe or any other case that followed. The standard was always dubious because there is no direct connection between this viability standard and the interest of the state, which is unborn life. Justice Thomas recently remarked how abortion jurisprudence has spiraled out of control. They are looking for an opportunity to rein it in. The need to revisit the viability rule is obvious, and it's pressing. It's just a matter of time and a matter of the court finding a suitable case for it. An appeal involving the Tennessee Heartbeat Bill that challenges the very meaning of viability could be that case. Second, in revisiting the viability standard, if the Supreme Court does not abandon it altogether, the court will have to clarify it or modify it to reflect the state's profound interest in unborn life. The Roe court did not envision what's taking place today, didn't envision children coming from environmentally controlled chambers. The first in vitro fertilization baby did not come until 1978. As that process establishes, life can and does exist in the form of an embryo outside the womb. Viability outside the womb. And this technology is advancing at a rapid pace, with news of successful womb transplants and serious discussion of creating artificial wombs for human babies in the near future. In light of these medical developments, the Supreme Court could easily conclude that the banning of abortions following detection of a heartbeat meets its viability standard. The in vitro fertilization process leads to embryos who are viable outside the mother's womb. Also, the Supreme Court could adopt the medical definition of viability as set forth in this bill, which is far better, objective measure. From a constitutional analysis standpoint, the question is not what the court has said, is what will the court say in light of the opportunity looking at it with modern medical advancements in mind. And it is eminently reasonable for this body to suppose that the Tennessee Heartbeat Law meets the constitutional standards. Third, it is highly appropriate, indeed is obligatory, for Tennessee legislature to draft legislation that is tied to its actual interest, and that's unborn life, not the flawed Roe viability standard. The Supreme Court has recognized that Tennessee may use its voice and regulatory authority to show its profound respect for life within the mother's womb. Tennessee Heartbeat Bill accomplishes this laudable goal. Any legislature concerned with enforcement must have a bright line rule directly tied to its legitimate interest. Having a law based on viability, as defined by Roe, would not serve this purpose. But the Tennessee Heartbeat Bill that links viability to the state's interest in unborn life, that's proper legislation that is both practical and constitutionally defensible.